Hello and welcome to the Wake Up Call podcast. In this episode, recorded on April 1st, 2014, I spoke with Mr. Stephan Kinsella about intellectual property and the nature of property. Mr. Kinsella is a practicing patent attorney, a libertarian writer and speaker, director of the Center for the Study of Innovative Freedom, and founding and executive editor of Libertarian Papers. He has written numerous articles and books on intellectual property law, including Against Intellectual Property. You can follow his work at stephankinsella.com. That's StephanKinsella.com, as well as by subscribing to his podcast, Kinsella on Liberty, on iTunes. For more information, please see the show notes page for this episode at wakeupcallpodcast.com/IP.
What is property? How would you describe property?
Well, so this is something I've been focusing on in recent months. I think actually the very concept of property, the word property is often misused or used in a misleading way. So the way you just asked it is probably the contemporary way of identifying ownable things, and you call them property. So like you say, what's your property? So that car is your property. I think that's potentially misleading. I don't mind using it. I use it myself sometimes. It's potentially misleading because the idea of property is just a characteristic, right? It's a feature of something. And it was originally used to refer more to the property right between the human actor, the human being, the owner, and something that he has the right under the law to control, a legal right to control, some resource. So really, the way I think of it is property rights are ownership relations between human beings and certain resources as recognized by other human beings in society, which is why it's a law or a legal institution. The word property is used ambiguously, sometimes to refer to the thing that's owned and sometimes to refer to the relationship between the person and the thing. But if you're like a scientist describing the nature of an entity or a feature of reality, you might talk about its properties, right? Or its features or its characteristics. And I think that's originally how property was used. The idea was that we observe that human beings act. We move around the world, we do things, we have purposes, we have ends, we have aims and goals, and we do certain actions, we perform certain actions to achieve these ends or goals. The actions we perform or an attempt to apply our knowledge of the way the world works, combined with the things we can physically actually control to change the course of events to achieve our ends. Okay? So the entire idea of human action is that you employ certain, what Mises, the Austrian economist Ludwig von Mises, calls scarce means. You employ these scarce means, or you could think of them as material resources or scarce resources. You employ them to change the events of the world. And those means include your human body and effort that you put out, combined with things that you use, like tools, right, or objects.
Sure.
And because these things extend the range of your effort, they are a property of you. That's why we started using the word property. So the first thing I would say is let's be careful about the word property, because if you use it a little bit indiscriminately, then the question starts becoming, is that property, is that property, is that property, and then who owns it, without first asking, is that the thing you're referring to, the type of entity or object that ought to be the subject of property rights in the first place? So, for example, if you see a runaway black man in 1825 in the U.S., your question might be, whose property is that, right?
Right.
But the first question would be, there's a human being who owns his body, presumptively. Who's the owner of that person? It's him. Why should someone else be the property, the owner of that property? Now, I would say that property rights refer to exclusive rights of control recognized by an established legal system in a given society, and the legal system does not have to be a state or government-based legal system. It can be just conventional or customary or anarchistic,
Sure.
just in general terms, theoretically. It's the recognized right to control a scarce resource, which is a means of action. So property really, in the economic sense, refers to anything that is a scarce means of action, something that we need as human actors to employ to get what we want. So typically that would include our human bodies, which is one special type of scarce resource or property, some people would say, and any other external resource in the world that is usable to accomplish an end and that was previously unowned. And if it was previously unowned, then someone can be the first one to use it and thereby establish a prior claim or a better claim than anyone else who comes after, except for someone that they contractually transfer that thing to. So in a way, with this very simple question, it unpacks a lot of the essence and elements of libertarianism and the Austrian political theory.
Now, from more of a historical perspective, I guess, how did these notions relating to property rights begin to transfer over into creative works and into a more intellectual sense, I guess? How did that develop?
You have a way of asking extremely short, simple questions that would take 3 hours to answer. It's a good question. Here's my view. And by the way, what I'm telling you is my particular perspective on things, and that's why you asked me, but I don't pretend that I am stating the uniform or the universal view that everyone holds. This is my perspective on things, so I'll be upfront about that. If there's something that's generally accepted, I'll try to indicate that.
Okay, yeah, and I want your personal view on these things.
So and this is my personal view that I've developed after about 30 years of thinking about this and having an initial set of views, and they refine, and then you think about where they came from and what makes sense, and then why did people go astray? Why did they come up with these terms? So this is what I've kind of come to. First of all, I think property rights as a system is a natural institution of human society. It's even natural in non-humans. I mean, even a dog will growl if you approach them when they're munching at their meal, right? There's sort of an innate sense of possession, and not only possession of this material object, this scarce resource, but the kind of right to control it. Like the first dog there's an assumption that he has the better control over it. That's why the others back off. Now, that's not a perfect analogy, but humans, I think, because we're social creatures, because of the way we've evolved and human culture's developed, our natural values are very social. We value each other. We have empathy for each other. There's a value to being part of society. There's also a value to participating in the division of labor and in being recognized socially as having a reputation for being someone who is going to be a reciprocator, right? Someone who respects rights as long as people respect their rights. Now, you could say, well, why not just be a cheater? The problem is we have minds and we live by concepts and we live by principles, and it's not easy to live in an ad hoc fashion all the time. And people do tend to know each other's characters, and that's why reputations matter and are useful and develop. And therefore, there is an incentive or a reason why actually just adhering to certain principles and having certain integrity and have a certain character makes sense, which is why I think overall most people tend to be civilized and respect rights and want to have some kind of system of rules that are socially recognized that we can all agree to and abide by, that allows society to function and allows us to all be better off. So I think that's the general context of why these property rules arise. Yes, they have arisen primarily and largely in a governmental context, and I don't think that's necessary, but that's just the way it's happened. They've also arisen in a context where there's always a small number of people who will deviate and will be criminals, and we accept that. That's like it's almost like an insurance type of calculation. We recognize that. There are going to be some cheaters, some malefactors, some bad guys, and then we come up with institutions to deal with them as well. So then the question is, what rules are going to naturally emerge and that people would adopt? And I think it's basically the ones we mentioned already. It's the first possession, because that's the natural way to figure out who owns something, or actually current possession. Whoever currently owns something is sort of like initially presumed to have the default right to control it. unless you could show that they had taken it from someone else, in which case then it goes back to a more deeper question: who had first acquired it and then had been robbed of the item, with some supplementary rules about contract and things like that.
Sure.
So that is the basic underpinning of the entire Western and indeed universal reason around the world and in human history why there's always been a prohibition against theft. And there's always been some kind of dim recognition of self-ownership rights, at least for certain people. And why murder has always been considered to be a crime and wrong. The basic notion is that we need rules that allow us to live in peace with each other and cooperatively and use these resources that are scarce productively without having to fight over them all the time. And the rules that people tend to adopt are the Lockean rules, the rules that are laid out by John Locke. Now, you asked about creativity and ideas. So here's where I think how we've arrived at the current situation. The current situation, just in brief, is that we have an overly legalistic understanding of what rights are. It's overly legally positivistic. That is, everyone thinks of law now as what the government legislature decrees in statutory form. So if you say, show me the law, you want to see a written law issued by a legislature. Now, this is one type of law. It didn't used to be the dominant type of law, and I don't think it's a legitimate type of law at all. But the point is that everyone now thinks of law as the decrees of a branch of a government. And today, a democratic, socialist kind of Western type government, right, with a parliament or a Congress, an executive branch, a legislative branch, and a judiciary. That's how people think of what law and what it is. Okay. Now, so back to Locke. Locke was trying to come up with a justification for this kind of basic natural state of laws. The basic idea that, if you acquire a resource that was previously unowned, you have a better claim to it than someone else. That's sort of the essence of the Western property idea, the essence of libertarianism, the essence of all legal systems. I mean, the details are interesting, but that's the basic idea. Now, Locke was responding to a guy named Filmer, who was sort of defending the feudalist system. And Filmer was trying to argue that, look, God, and everyone had to agree with God because this was, 300 years ago. So even even Locke didn't deny that premise. But so Filmer was like, God owns the world, and he gave it to his creation, which was Adam, the first man. And Adam owned the entire world and was able to transfer it to his descendants, which justified the monarchies or the feudalistic system, you see. And so Locke wanted to get away from that. He wanted to defend a more individualist, decentralized perspective. Right. So he said, no, God gave the world to man in commons, which to our mind means unowned. Okay, in commons, unowned, sort of the same idea. And therefore, as long as it's unowned or unused, the first guy that comes along and starts using it is the owner. Now, why? Because he owns himself. Now, he bases this upon, God gives everyone a propriety in their own body. Again, the word propriety is used as a relationship or a right between the person and the material resource of his body. The body is not his property. It's a property of himself, or there's a proprietarian relationship. Okay, so you own your body, according to Locke, or yourself, as he calls it, somewhat metaphorically. And therefore, you own your labor, things that you do with your body. And therefore, you own unowned things or things in the commons that are not previously used by someone else that you mix your labor with. So this is where the labor idea comes into the picture. It comes into the picture with Locke's kind of metaphorical, quasi-religious argument in defense of or in response to feudalism. Okay? Now, I think that's where that was a mistake, and that's where the mistake set in. Now, and I'll explain in a second why I think it's a mistake, but what the mistake led to was this modern notion of intellectual property, okay? Basically, it unmoored the question of property from the simple question of, if we find a scarce resource, that is something that two or more people can have a conflict over, okay, if we find a resource like that and there's a conflict and we need to decide who owns it, we can answer that question by resort to the basic questions of first possession, contract, maybe tort, but very simple questions, okay? So the question is always for the libertarian, for the proprietarian libertarian, identify a scarce resource that is possibly in dispute, and then answer the question, who has the property right in it? That's the question. The question is not what is property or is that property. But from the Lockean point of view, we were unmoored from that anchor because of this labor issue. So then it became an analogy type of argument or an overly metaphorical argument. So the analogy is, well, we all sort of know intuitively, our concepts aren't really well developed. We know intuitively that if I build a farm on an unused piece of ground, that I am the owner of that. And if I have bred these cows, I'm the owner of that. Or if I've raised these crops, I'm the owner of that. Or if I've made an axe out of steel that I found, or iron ore that I found, I'm the owner of that. And that's all true. But what the reasoning was, well, why are these things more valuable than they were before? Well, because I labored on them. And I own myself and I own my labor. So it's sort of this combination. And that's not actually incorrect, I think. It's just overly metaphorical and not precise, and it can lead you into error, as I'm about to try to demonstrate. So the idea is that I own my body, I own my labor, whatever that means, and I therefore own the increased value of these natural resources that I homesteaded, okay? So then they said, well, by analogy, or maybe by induction, they said, well, the general principle here is that you own the fruits of your labor. You'll hear this expression a lot, the fruits of your labor. Now, in the law, the word fruit simply means the result of something. In fact, in the civil law, the second great legal system in the world, if you make interest on a loan, it's called civil fruits. Okay. A natural fruit would be, the calf of a cow or the actual fruit falling from a tree. Right. And the idea is that if you own the tree, you own the fruit falling from it, natural fruit. If you own a cow, you own the calf that comes from the cow, natural fruit. If you have a piece of capital that you can invest and get rent on or interest on, the interest is the civil fruits, and you own that because you own the resource. And I think that's all true, but the reasoning is not correct. The reason that I own the fruit from the tree is because I own the tree. It's not because there's a general principle that you own the results of things that you own. But if you make that inductive argument, then you get to the point that we've gotten to now. Then you get to the argument that, well, just as I labor on the fields to produce crops, and I, quote, therefore own the results of my labor, there's a general principle at work here, and that's that I own the results of my labor. And in fact, John Locke said that we own our bodies and we own our labor, therefore we own the results of our labor. Now, fast forward to the modern world where we have technology, high technology, now software, computers, international commerce and trade, and a widespread recognition of the value of commerce, free markets, international trade, technology, and so on. And a widespread understanding that labor is not just physical labor. Labor can be intellectual and it can be mental, and you can produce great things with your mind or with mental efforts. So all these ideas blend together to lead people to assume that just as the product of your labor in a physical sense, like a farmer owning a field, ought to be subject to property rights, therefore, the product of your labor in a mental sense ought to be subject to property rights. And this has resulted in this has been used as a justification for various intellectual property regimes, most of which have been legislated. The two primary ones are patent and copyright. Trademark and trade secret are also important. For the software context, I think probably copyright's the most important. Patent is probably number two, and trade secret is somewhat used as well. So that's what has happened. Actually, in fact, I think that these legal systems, especially patent and copyright, originated for totally different reasons that we understand now. And these justifications were given after the fact. So copyright arose out of the desire of the church and the state in their unholy alliance to control thought, to censor speech, to prevent the unauthorized spread of ideas by the Gutenberg printing press that the church and state didn't want spread. So this was originated from a system of state control. It's basically control of thought and censorship. And it still results in that today, by the way. After the fact, it became regularized and institutionalized and co-opted by the Stationers Guild and the publishing monopolies and all this. And then when people start criticizing it, then they say, well, we know that there are natural rights based upon labor and all this. So they kind of come up with an after-the-fact justification. Patents were similarly not the result of anything like Locke's original theory. In fact, Locke did not agree that his homesteading idea justified intellectual property rights. He agreed that they were just temporary civil measures the government could undertake to promote some kind of activity in the economy. So he didn't think there were natural rights, nor did the American founders, by the way. They were not viewed as property rights, which is why they only last a finite amount of time, right? Patents last roughly 17 years, copyrights around 100 plus years. If they were real natural property rights, they would last forever. Right. So the patent monopoly originated back in the practice of the monarchs, the king, the crown, granting basically protectionist monopolies to various favored court cronies and other people. So one guy gets the right to sell playing cards or export sheepskin or whatever in a given region. And in exchange, he grants loyalty or maybe even helps to the king or maybe even helps the king collect taxes. So it was basically a grant of protectionism and monopolies, which is why the very first patent statute, 1723, in England is called the Statute of Monopolies. I mean, no one, this is really not disputed. It was Statute of Monopolies. Okay. So then after the fact, the people trying to justify these provisions. So basically 1700s, this was becoming more regular in England. And when the U.S. was founded, 1789, the framers put copyright and patent into the Constitution as powers Congress had. Right. Okay, they didn't really give it a lot of thought. They didn't give. I mean, I think they were going mostly by inertia and partly by self-interest. A lot of them had, these are the most educated people at the time, so these are going to be the guys that are the authors. So they have some interest. They were the most intelligent guys. Some of them are going to be the most prolific inventors: Jefferson, Ben Franklin, etc. Sure. So you could see why they would put that provision in the Constitution. They didn't have any empirical studies showing it was legitimate. They didn't have a theory of why it was legitimate. But so these systems got started, and then you have copyright and patent battles start happening in the ensuing decades. The economists, becoming increasingly free market in Europe and the U.S., start going, these are protectionist measures by the state, which are contrary to the free market and to individual property rights and human freedom. So there was a huge backlash and a huge battle. And in response, by now there had been vested interests who had risen up, who were dependent upon copyright, like the publishing industry, and patent, like various centralized corporations and companies like this. Sure. So they start mounting a rearguard defense. And their defense is, well, it's really a natural right. It's a type of property right. It's part of commerce. It's part of capitalism. How dare you? Are you against innovation? Are you against creativity, et cetera? Forgetting the fact that patent law originally stifled innovation and still does, and forgetting that copyright originated in the attempt to stifle free thought and freedom of expression. So I think that's what happened. I think the fundamental mistake was, and I don't blame Locke for this. He did a great job at the time, but I do think it was a misstep. David Hume, who came later, himself recognized that Locke's argument is good and sufficient without that unnecessary step. And by that step, I mean the step that you own your body, therefore you own your labor, therefore you own what you mix it with. First of all, as Hume pointed out, saying that you own your labor is overly metaphorical. It's vague. You might as well say you own your action, which is what Mises would call labor, is a type of action. And to say you own your action is sort of a weird expression. In my view, it's double counting. It's double counting because you're saying that you have the right to own your body and you have the right to own your action. But my thinking is that if you own your body, that gives you the right to act as you please.
Right. Yes.
It's like saying you have a right to your body and a right to privacy and a right to free speech. I'm like, well, there's no such thing as a right to free speech per se. There's a right to do as you please as long as you're not committing aggression.
Right.
And if you have the right to own private property, like a home or a venue, you can say whatever you want within that venue. Or you could own a printing press. Private property rights give you the right to own a printing press, which gives you the right to sell a book. But it would be double counting to say you have a right to own a printing press and the right to sell books. It's like, well, the first one is sufficient to cover the second. Okay, it's okay to look at the benefits of these rights. So I think that this sort of imprecision in thinking. So to get back to Hume, so Hume said that Locke's argument works if you take out that step, and I agree with that. If you basically say, yes, I own my body. Now, why do I own my body? Well, you can believe you own your body because God gave it to you. I guess that means you're really God's slave, but compared to everyone else, you own your body.
Right.
Or you could believe you own your body because you are the one that directly controls it. You have a better claim to it than anyone else, unless you commit a crime, which might change the presumption. But the default state is you own your body. Now, who would be the owner of some object, some external resource that's not a human body and not a living actor with a property right in itself? It would have to be the first user, because if it wasn't the first user, you could never have a first user. In other words, no one would ever be able to go use a resource as unowned if they weren't going to have the best claim to it. If the first guy that uses a resource is not the best claimant, then the second guy who takes it from him doesn't have a right to keep a third person from taking it from him, which means we don't have property rights at all, which means we're living by tooth and claw. We're living by the law of the jungle. We're living in a might makes right situation, and we're not talking about ethics and norms and rules anymore at all anyway. If you're going to have rules and norms, as far as I can see, the only justified set would be the Lockean set. So I do think that there was a big misstep there. I think Locke did not need to say that we own our labor, and he didn't need to say that we own things because we mix our labor with them. That we own. He just needed to say that the first user of a resource has a presumptive better claim than anyone else. And that would have avoided this entire false direction we've taken with defamation law, reputation rights, that is, trademark, patent, copyright, and even some aspects of trade secret law.
Now, one of the things you mentioned in there was how these laws stifle innovation and creativity.
Yes.
And obviously, you explained that you explained why that is to an extent in there. But I think the general consensus seems to be that these laws are necessary.
Yes.
For creativity and innovation.
Yes.
So how did that consensus arise, and what are some examples of that not playing out the way most think it does?
So what I think happened is, first of all, I think intellectual property, especially nowadays, patent and copyright, which I think have gotten to be a more significant part of the economy since the internet, and since international trade the couple decades before that. It's highly arcane, highly specialized, highly controlled by bureaucrats, judges, and lawyers and special interest groups who understand its workings, and it's extremely complicated. So first of all, I think most people don't understand it, so they accept the common wisdom. They're in favor of innovation, and they're in favor of property rights, which is to their credit. I'm talking about like the average intelligent layman.
Sure.
And they have heard that intellectual property is a type of property right. Well, number one, it's called a property right. It's called intellectual property. It wasn't called that originally. It was called patent monopolies and statutes. But then in defense, in response to the attacks by free market economists, the special interest groups started calling it intellectual property. So it was just a propaganda move. So I think that the reason people believe this is because it's very complicated, very detailed. It requires a lot of economic understanding as well. And they have accepted the propaganda that has been perpetrated by the state and by the special interests that do benefit, at least temporarily, from these government-granted monopolies. Now, there are two main defenses of intellectual property given by its defenders. The primary one, which is rife nowadays, is a more of a utilitarian or empirical argument, which is the argument along the lines you suggested, that innovation as a general thing, which would include artistic creation and technical findings, innovation, discovery, or either necessary. Intellectual property is either necessary for this, or at least that we have a lot more of it. We would have a deficit of it without intellectual property law. The second argument is more of a natural rights one, which is that because you create something, you have the right to own it. Now, as I've mentioned, I think that the second argument is pretty easily dispatched with. Right. It's too many of these arguments of the latter type are almost semantic. It's almost like saying it's arguing by possessive. If that's my wife, well, I must own her because the word "my" is possessive. You can make these simplistic arguments, and they do this all the time. And the proponents of IP, I think, are pretty much unprincipled and dishonest, and they will switch back and forth. You take your typical patent lawyer, which I'm a patent lawyer, and most of my fellow ilk are in favor of patent law, big surprise. But almost none of them have a good argument for it.
Right.
One reason is there's no good argument for it. Number two is they don't care. They just want to keep the money flowing.
Sure.
So they will just say what they need to say to shut the argument, to stop any kind of measure blocking them and to keep things going. The first argument is empirical, and I don't want to be too critical of empiricism and utilitarianism. There's a pragmatic aspect to it, a consequentialist aspect. The idea is that, in general, property rights laws that we favor have good consequences, and there's nothing wrong with that. That's a good thing. So let's just break the argument down into two types. Number one, the argument which you kind of summarized earlier, innovation is impossible without intellectual property law, or there would be no innovation without IP law. It's really hard to make that argument, and no one seriously tries to make it.
Right.
You really cannot argue that if we abolished patent law tomorrow, there would never be any more innovation in the history of mankind. No one really believes that. There would still be some, right? So instead, their argument is that we would have less. Okay, so what that means is they're imagining that there's some optimal or higher amount of innovation that we could have if we just change the law in this way. So they really are just tinkering in the economy, right? They're social policy tinkerers. They want to adjust the levers of policy to maximize innovation, or to at least improve innovation a significantly large amount, that the value of which to society is much greater than the cost. Because I think if you're an honest empirical advocate of IP, which I think most people are, they just don't know what they're talking about. I think that's their motivation. I think if you said, listen, if patent law costs $1 trillion a year in cost on innovation, but it only resulted in $200 billion more additional innovation, it's not worth it, right? They would agree with that. So their implicit assumption is the opposite is the case, okay? Now, as I mentioned earlier, when the founders of the U.S. in 1789 adopted the Patent and Copyright Clause, they didn't have any empirical studies demonstrating anything, okay? So it was sort of a hunch. Let's just say it was a hunch. Let's give them the benefit of the doubt. But we've had 200 plus years of fancy econometrics and empirical studies, especially in the last 70 years. And you would think by now, if they're right, there would be some kind of clear empirical evidence showing that patent laws massively benefit the economy. So my first response to your question about the empirical claim is that the burden of proof is on them to show it. And by now, they should have been able to show it.
Right.
but they haven't. All the studies are either they say we can't figure it out, it's too messy, which is not surprising because value is not really measurable. Or they conclude that from what we can tell in this sector of the economy, copyright law or patent law causes a huge multi-billion-dollar deadweight loss. Okay, I'm just talking about what the studies show.
Right.
So even in 2014, today, right, 220 or so years after the founding, we still don't have any kind of clear showing that the empirical case for IP is justified. Now, you will hear dishonest, disingenuous, offhand arguments like, well, the U.S. has been the most prosperous and most technologically advanced country for the last 200 years, and we've had IP rights since the beginning, so therefore IP rights must be the cause of that. Now, in my view, that's just a very simplistic argument which confuses causation with correlation, or vice versa.
Sure.
You could also argue that because we've had tariffs or a war about every decade since 1789, or slavery for the first 100 years, that's why we succeeded. I mean, they're correlations, but they're not causation. In fact, I believe that it's the other way around. So now, why would patents cause retard innovation? Well, one reason patents would retard innovation is that anyone seeking to compete with someone to make a similar product, let's say Samsung wanting to make something like an iPhone, if they make it too similar, which is what it means to compete, they're going to get sued for patent infringement, and they know this. Okay, and so a lot of companies never even do it in the first place, which means they never engage in the innovative activities that they would have engaged in to improve the product or to morph it. So there's lost innovation there. Bastiat and Hazlitt talked about the seen and the unseen. We can see the benefits of some policies. If there's a food stamp program, we see someone who can buy food now, but we don't see the harm that's done to someone who had to pay the taxes for the food stamp. And so that the cost of that policy is unseen. And I think that's largely the case with innovation. People who are advocates of government funding of innovation can point to Tang. They can say, well, we have billions of dollars spent by NASA on moon missions, and one result was Tang. Tang might be fine, might be a great innovation. It was popular for about 3 years, as I remember in the 70s. But that doesn't show that the money that was spent as developing Tang and other things for astronauts couldn't have been invested better elsewhere. Another example is that a lot of companies have to engage in a lot of money to what they call design around a patent. So if you're aware of a patent out there, which takes money to be aware of in the first place, you have to hire patent lawyers like me just to research this and search it and educate you on this. Then you have to make a decision about what kind of product can we make that's going to be popular, that's different enough from this other product that we don't get sued. Which means you put features into your product that you wouldn't naturally have done, okay? Which means it's less efficient than it would have otherwise been, which means there's a cost, which means there's a waste. And when there's a waste, there's less innovation, right? Because there's less resources around to stimulate the innovation. That's another example. So patents actually distort the entire process of innovation and research and development in various ways. So one way is that patents are awarded for practical applications of abstract ideas, but not for the abstract ideas themselves. So, for example, Einstein could not have gotten a patent on E equals MC squared, okay? But someone who took that formula and used it to develop a transistor or maybe something else could have gotten a patent on it. So what this does is it leads to a distorting effect in science and industry, where the more abstract fields are less rewarded and the more practical applications are more rewarded. So what you have is a government pushing one over the other. Now, you could argue that one is better than the other, but there's no reason to believe that the government's decision is right, and the government artificially distorting the economy and the technology arena is a good thing. Government distortion usually means government is destroying value. So those are just a couple of examples. There are another example is if you think about the Samsung, say Apple patent wars. Okay, what you have is a few very small, a small number of large players like Apple, Samsung, Motorola, and others, and they're the manufacturers of, say, smartphones. There's other examples in other industries like chemicals or laser printers or whatever. But the reason there's only a small number of players, the reason it's like a cartel or cartelized industry, is because only these big players have the resources to acquire vast arsenals of patents that they can use as bargaining chips with each other when they sue each other. So, if Apple sues Samsung or Motorola or Google, the other guys can fight back with their own patents. They can spend $50 million a year on their lawyers' fees, and eventually they come to a settlement, which the shareholders suffer in the cost of reduced returns, and the price of cell phones goes up by a few percent, and the customers have no choice but to buy an Apple or a Motorola or a Samsung, but the price is $5, $10 higher, so they're paying these fees in effect. But they have a limited choice because you have an oligopoly or a cartel. Because small players can't enter the field. If you wanted to start a mobile smartphone startup tomorrow, you're invariably bound to violate some of the patents of these big players. And you won't be able to defend yourself. You won't be able to afford $3 million of patent lawyer fees just to defend yourself, especially when you'd probably lose because patents are legitimate. I mean, they actually will be enforced quite often. So it results in reduced competition, cartelized, oligopolized industries, which have a lower incentive to innovate because they don't have as many people to compete with. They can rest on their laurels. So there's lots of reasons to believe that any reduction of wealth, which is a result of any government program or action, or any reduction in competition, which is the reduction of a lot of government laws, especially any government meddling with the technological sector of the economy, is always going to reduce innovation and overall consumer welfare and wealth and freedom. And this is exactly what the patent system has done. And the copyright system has resulted in reduction of freedom and wealth in other ways as well.
Now, have the trademark or trade secret systems had similar effects? I guess those are more done at a state level, right, than a federal level in the United States.
Well, here's how I would rank them. I think that the copyright system, I think the patent system is the worst in terms of dollar amounts. My suspicion is the patent system probably imposes $500 billion a year or more on the worldwide economy, or maybe more, because of reduced innovation and related effects. It's like a huge tax on growth and technology. The copyright system probably doesn't impose that much in dollar terms, but it has heavily distorted the culture, the way we think about consuming music and media. But it's even worse than patent, I believe, because it's the biggest threat to internet freedom, because it's being used by the state as an excuse to increase controls on how people trade information on the internet because of copyright piracy. So you have the Stop Online Piracy Act. You have upcoming treaties like the Transatlantic Pacific Partnership, TPP.
Right.
Things like this that are coming that are serious challenges to internet freedom. And I think that's so important because internet freedom is so important for liberty and to fight the state. Right. And so copyright to me is one of the biggest threats we have out there. It's being used along with pornography, terrorism, gambling, money laundering, all these state regulations, which are excuses the state uses to shut websites down or to go after people for just exchanging information on the internet. Bitcoin now. But copyright's one of the biggest, probably the biggest in my view. So those are the two big looming problems. I would say, so if you want to put like copyright here, patent here, and then trademark way down here and trade secret way down here. Trade secret is largely state in the U.S., state level law. It's developed out of the common law. But to my mind, even that's unjust because you don't really need the government to give you permission to keep something secret.
Right.
You can just keep it secret.
Right.
The only part of trade secret law that goes beyond that is that the government says that if you can prove you made a diligent effort to keep something secret and someone still leaks the information, then you can go to a government court and get a court order, an injunction against third parties, people who had no contract with you whatsoever, and the government court can tell them on pain of being jailed for contempt of court that they have to keep secret and not use this information. So I think it's totally unjust. I think that if you have no contract with someone and you didn't steal the information or you didn't break into someone's property to get the information, if you stumble across information, then the government has no right to tell you not to use it. The person that has the secret should have been more careful with it. And if they're not, too bad. But it's not a big problem. There's a couple of notorious examples. I think Apple, remember when the iPhone 4S or something was left accidentally on a bar stool in Silicon Valley by one of the employees testing it when it was still secret, and someone found it and started posting photos about it on the internet? Well, Apple's lawyers and the police showed up at this guy's house the next day under the guise of trade secret law, demanding to search the apartment and to take this iPhone. Okay. So to my mind, even trade secret law can lead to sort of quasi-police state protectionist tactics, although I don't think it's a big problem or a big factor. Trademark law is in between. Trademark law used to be a common law, state law-based thing primarily, and it was said to be based upon a combination of two things. Number one, the right to your reputation, which I think is a type of IP right based on this Lockean labor idea. If you build up your reputation with the consumers, you have a right to it. And this is linked in with this economic or financial concept of goodwill. You know, they always kind of put this factor in the gap charts about how much of your business is this, where's the rest? Well, it's in goodwill, whatever that is. Okay, so that's one part of it, which I think is wrong. But again, it's not that harmful. And the second part is they say that, well, it's a way of preventing consumers from being defrauded. So if one of my competitors starts using my logo in a deceptive manner, it could defraud consumers, and we all agree that's bad, and I agree that's bad because I'm a libertarian, and fraud is one thing that we agree is a species or type of aggression. You can't defraud someone. However, the trademark law, even in the common law system, even in the state law system, and it's much worse now, by the way, but even in the original system, never required the plaintiff in a trademark suit to prove fraud of a consumer. So it wasn't a part of the cause of action. You didn't have to show that the defendant was defrauding any actual person. But yet they use this fraud argument to justify why we have these laws. So they're having it both ways. What they had to show was a likelihood of consumer confusion. Okay, fine. I could live with that if I had to. It wouldn't be the worst thing in the world. It's like fraud. It's not exactly fraud. It's just sleazy, but okay. But number one, even that kind of trademark law has been and today is increasingly used to stifle free speech. It's used all the time by these companies. They will use trademark law. They'll throw that into their complaint letter. They'll get sites taken down, or they'll sue people. They'll say, what your complaint about my product was a violation of my trademark rights, even though you're not really confusing any consumers or committing any kind of fraud. The worst thing about trademark law is that it has become federalized. There's something called the Lanham Act. I think it's passed in the 50s. It was a federal version of trademark. Because trademark is not in that constitutional clause I mentioned earlier, right. Patent and copyright are, the federal government had to find another source of authority to justify legislating in the realm of trademark. And by the way, they've also legislated in the realm of trade secret. There's there's a theft of trade secrets provision, which is a federal law, which makes it a federal crime to commit certain types of trade secret theft. But anyway, the Lanham Act basically only federalizes trademark law to the extent that we're talking about a mark used in interstate commerce. So that's why there's a system of state trademark systems in harmony with the federal system. In Europe, there's a similar thing with the European Union, and it's all over the map. Whereas there's no really state patent or copyright law systems that I'm aware of. It's all federal. So the state Federal Trademark Act originally was just a federal version of this common law version. But in the meantime, they've added in the 1990s, I think under Clinton, they added the anti-dilution requirement, which says that there's a new trademark right, which is that you not only have the right as the owner of a trademark to have someone not infringe your trademark by using the mark in a way that's likely to confuse consumers, you also have a right not to have your mark tarnished or diluted, the value of it diluted. So you see, it goes back to this Lockean stuff. So the idea is that you have the right to the value of the mark. And if someone reduces the value of your mark by their actions, they violated your property rights. And dilution has nothing whatsoever to do with consumer confusion or fraud whatsoever. But you'll talk to libertarians or free market types, and they'll say, well, if you're against trademark law, you're against fraud, even though the trademark law is not rooted in fraud at all. Let me give you one colorful and interesting example. A few years ago, this is more of a copyright case, but it's an example of how companies will use these things. Omega, the watchmaker, the one James Bond likes. They sell these watches that are extremely expensive. I can't remember the numbers, but let's say it's a $15,000 watch in the U.S. Well, they sell it in other markets too, and they were selling it in one of these South American countries for a significantly lower price because just of price discrimination, right? Because they knew they couldn't get as much for it. Let's say $6,000. So you had some enterprising arbitrageur, right? He would go down there to South America, and he would buy the watch. It's a legitimate watch. It's not a bootleg. It's not a knockoff. And he would, actually, it was Costco doing this. I don't remember if he sold it to Costco or Costco did it directly. But anyway, Costco was selling these Omega watches in their U.S. stores for a significant discount from the local Omega stores because they were getting them from the retailer in South America. So what Costco did was they couldn't stop it because it wasn't a copyright or patent or trademark infringement because it was a legitimate sale. It was a legitimately sold watch by them. They really couldn't complain how the owner used it after that, right? And we have free trade, so it could be sold here. So what they did was they inscribed this little globe symbol. They hired an artist to make a globe, like a map, and they put a little globe symbol on the back of it. Now, guess what? The globe is subject to copyright. Okay? So then they took Costco to court, and they won on the grounds that the so-called first sale doctrine of copyright doesn't kick in if the first sale isn't within the territorial borders of the U.S. because the U.S. law is only domestic and all this kind of stuff. So that's one example. A more recent example was this Wiley & Sons case. I don't know if you heard about this one.
No, I have not.
So Wiley is a big academic publisher. So they sell textbooks here for, to students for hundreds of bucks a book. And they sell them in, I can't remember, some Asian country, Vietnam or somewhere, for like maybe 1/4 or 1/5 as much, and on cheaper paper too. But it was the same book. And you had this student who was over here, an Asian student, and he would get his relatives to buy the books and send them over here, and he would sell them over here. He was making hundreds of thousands a year just on the arbitrage. And he was not in violation of copyright. Well, you would think he wasn't because these are not knockoffs. They're not bootlegs. Same thing happened. I think it's called kurtzing, this case. So these are examples of how these laws will be used and have been used routinely. And trademark law and patent law are used like this all the time as well to stop free trade, to impede progress. In the U.S. case, in the patent case, something similar happens with drug reimportation. So you'll have Bayer, one of these big companies, big pharmaceutical companies, sells a version of their drug in Canada, and they're sold at a much lower price, mostly because Canada imposes price controls because they're more socialist in some ways than we are. Well, those are legitimate products, and the owner can do what they want, and there's a practice of reimporting them down here. So, of course, the big drug companies get the Federal Trade Commission to intervene and say, well, you can't import this. Or maybe it's the FDA. I can't keep it straight even. The food to say that, well, you're selling a drug here that's not approved by the FDA. It's like, well, it is approved by the FDA. It's the same company. It's approved in the U.S. You're selling it in Canada. So then they say, well, it's an FTC issue. It's a trade issue. It's like, well, we have free trade. So you had actually libertarian. This is about 10 years ago, 9 years ago, this dispute broke out. You actually had libertarians at the Cato Institute, which is normally free trade and libertarian, like I can't remember, Doug Bandow, Richard Epstein, arguing that the federal government in the U.S. should not allow drug reimportation of this kind of drugs because it's a way of doing an end run around the patents. So you basically have the IP patent system being used even by proponents of free trade as an excuse to limit free trade. So you can see the tension there, the conflict. You've got to really choose, in my opinion. You have to choose, do you want competition? Do you want people to learn? Do you want them to be able to emulate what they learn and what they see? And do you want private property rights and individual liberty? Or do you want a cartelized, government-manipulated and distorted system of protectionism and thought control and control of the internet and free speech? I think that's the choice we have to make.
And this question, I guess, is more as an aside. It's not directly related to what I was planning to discuss, but you mentioned it in passing a little bit, so I thought I'd ask it anyways. When you were discussing trademark, you talked about fraud and that argument that goes along with that as being fraud when trademark laws need to be enforced, or when people are attempting to enforce them. So the term fraud seems to get thrown around a lot without really, and I'm sure I'm opening up a can of worms that can be discussed on end for hours.
But yeah. It's a pretty simple one.
It's never really been. Well, at least I've never really heard it fleshed out in detail exactly what is fraud and what isn't fraud.
No, you're completely right. This is I just had a Tom Woods podcast where I was trying to go through some of these things the other day.
Yeah, I listened to that, and I was really hoping that you would discuss fraud in particular. And
I don't think we got into it. I did have a couple of other longer talks I've given where I did go into it in more detail, but quickly. This is another one of those terms that you have to try to be precise about. It's used in a variety of ways. Most people think of fraud as some kind of deceitful activity or some kind of shadiness or dishonesty. Another one on an aside is the word plagiarism, which they sometimes conflate with each other. But you'll hear people say if you're not for copyright, then you're for plagiarism. So they're doing exactly what, for the copyright case with the plagiarism idea, what people do with trademark and the fraud idea. They will get you to admit that as a human being, you think there's something wrong with plagiarism, and then they'll equate that with something that's embodied in the copyright statute. And if you're against copyright law, then you're for plagiarism. But then they don't insist on plagiarism being part of the copyright standard. Plagiarism and copyright have almost nothing to do with each other. One's a type of dishonesty and taking credit for something you didn't do, and the other is just reproducing patterns of information that you don't have the permission to reproduce. Most cases of copyright infringement are not plagiarism at all. If I sell you a bootleg copy of the latest, Steven Spielberg movie, there's no plagiarism involved. I'm not pretending I'm Steven Spielberg. I don't put my name on the movie. And most cases of plagiarism are not necessarily copyright. If I plagiarize a long excerpt from Aristotle in my class paper, I may be committing plagiarism, but there's no copyright involved because that's a public domain work. So these things are actually not related. In the fraud case, most human beings would say that dishonesty as a general thing is bad. Honesty is a virtue. I agree. Also, it's wrong to steal from people. I agree. It's wrong to murder or attack people. The only way you can make fraud a type of crime or call it a species of aggression or a type of aggression or the type of thing that the law is justified in prohibiting with the force of law is if you have a very clear understanding of the nature of property rights and the consequent nature of contract. Okay, so property rights, as we discussed earlier, means the legally recognized right to control a resource by a person who's seen as the owner. And actually, it could be defined more narrowly still. The right to control is really not the right to control. It's the right to exclude. It's only the right to keep people from using this resource. Doesn't mean you have the right to use it. In fact, that's part of patent law too. If you have a patent on an invention, it doesn't mean you have the right to use that invention. It only means you can stop people from doing it. So the reason I say that is, like, let's say I own a gun. If I'm the owner of that gun, I can prevent you from using the gun if I want to, or I can permit you to use it. That's called license or permission. Or I could, so my permission could be temporary, it could be conditional, it could be limited, it could be unopened, it could be open. I could give you the gun as a gift, or I could sell you the gun in exchange for money. So there's various things I can do. But I don't have the right to shoot you with the gun if you're not committing aggression against me. So merely having the right to gun doesn't mean I have the right to use it. It just means I have the right to do anything with it I would have the right to do with anything else, so long as I'm respecting others' rights. Okay? So that's the basic idea of property rights. Contract flows from this. Contract is just the exercise of this right to grant permission or to deny permission of access of the owner. That's what a contract is. A contract is some kind of communicated assent or consent to someone else's some type of use of an object that you have a property right in. That's what a contract is. Okay? Contract is not a binding promise, which is what most people think of it as. And so you first have to get contract rights clear. And Murray Rothbard wrote clearly on this, and I think established a revolutionary new way of looking at contract rights. So once you understand that contract is just an implication of property rights, and property rights is the fundamental thing, then the question of fraud comes in. And to my mind, fraud, what people are getting at when they think of typical acts of fraud, and the reason why it could be classified as a type of trespass or theft, is because it's what I would call what the law calls theft by trick. Okay, so imagine you're going to have surgery and you give the doctor consent to take your appendix out. Okay, now you wake up and your appendix is removed. Now, can you sue him for assault and battery? No. Why? Because you consented, right? But let's say your foot is missing. Now, he chopped your foot off. Now, did he commit aggression or assault and battery? I would say yes, because you didn't consent to it. So then the question becomes, what did you consent to? This is where this communication aspect comes in. It depends upon what a reasonable person thinks is actually being communicated between the parties. You're the owner of your body. What did you consent to? I consented to an appendicitis. I did not consent to an amputation of my foot. Okay? So it depends upon what the owner of a resource manifests as his consent to someone else. And this is what happens in any kind of transaction between people in the free market. A purchase, a sale, an exchange, etc. And this is where fraud can come in my view. Fraud is analogous to the case of the surgeon removing your foot when you didn't consent to it, or when you gave uninformed consent, okay, depending upon the circumstances. So an example of fraud would be I'm exchanging a basket of apples for your chickens. Okay. Now, there's an implicit or maybe even explicit communication going there. My communication to you is, these are good apples. They're regular apples. You know, they're not made of lead or poisoned or full of bombs or whatever, to my knowledge. And I will transfer my ownership of them to you if and when you transfer ownership of your chickens to me. And likewise, there's certain representations implicitly or explicitly being made by the chicken owner. So if I'm giving you rotten apples for your chickens, knowingly doing this, then I know that you're saying you can have my chickens if you're giving me good apples. So your consent is like the consent to the surgery. It's like I said, I'm going to have surgery, and the doctor says, well, I'm going to do an appendicitis, but if I find a horribly cancerous lesion on your heart while I'm in there, okay, not your heart, you're somewhere else near there.
Right.
Do I have your permission to remove it? And I say, yes. And those conditions, yes. But I specify certain conditions. Well, you're doing the same with the chickens. You're saying, I'm giving you these chickens, but only if you're giving me real apples. You follow me?
Yeah.
So if I give you bad apples for the chicken, and I take the chicken, now I've got possession of your property, and I'm using it without your authorized consent, without your informed, because I know that really the condition hasn't been satisfied. The condition was that I gave you good apples, and I'm knowingly violating that. So I'm basically taking your property, your own resource, without your consent. That's why it's a type of trespass. So fraud is simply a way of failing to meet a condition of a conditional transfer of property rights to an object.
Okay.
It's so not every form of dishonesty can do that. So let's say you meet a girl at a bar, and she likes guys with black hair, and your hair is really blonde, but you have it dyed black, and you don't tell her that your hair is really blonde,
Right.
and you use that to seduce her. Is that rape? No, she consented to the rape. And there's no exchange of title there, actually, right? Or other forms of fraud, like where you deceive someone into doing something, or you're just a deceitful, dishonest person. Those are reprehensible bad actions, but they're just dishonesty. They're not in the context of a transfer of title to property where you could somehow characterize it as theft by trick. So I think fraud has to be characterized as some kind of theft by trick. And if you think of it that way, then it limits the scope of when fraud, and it also shows why fraud is a type of aggression.
Right, yes.
It shows why, and it limits when it can be applied.
Okay. All right. Well, thank you for that explanation, and thank you for all your time.
Thank you for listening to this episode of the Wake Up Call podcast.
If you would like to listen to more episodes, please subscribe, rate, and review the show on iTunes, or subscribe on Stitcher, and check out our website at wakeupcallpodcast.com.
There you will find show notes pages and comment sections dedicated to the show. You can also email us at contact@wakeupcallpodcast.com if you're interested in being interviewed for the show or have any other suggestions.
Thank you.